Welcome to the briefing for July 28, 2026, sponsored by Clinician Assist. Today's theme is the narrowing gap between the products AI companies build and the boundaries regulators are willing to tolerate. This week's index tracks how courts and regulators are moving to define liability where internal corporate policies have failed. Over the weekend, hundreds of private Claude conversations containing cryptocurrency keys, medical records, and legal notes surfaced in Google and Bing search results. The share feature created public URLs that search engines indexed as intended. No breach occurred, and the feature worked exactly as designed. This is the third time a major lab has seen a sharing feature expose private user data. Without a federal confidentiality statute for chatbots, the legal risk currently sits with the user, though the repetition of these incidents is drawing scrutiny toward industry design norms. The European Commission has adopted a final decision under the Digital Markets Act, issuing legally binding orders that require Google to open the Android ecosystem. The compliance calendar is now fixed. In January 2027, Google must begin sharing search query data with rivals. By August 2027, competing AI assistants must have the same technical access as Gemini, including custom wake words, the ability to read screen context, and cross-app execution. This converts the Android assistant slot from a private preserve into a contestable market. In the EU, rivals will now gain this access by law rather than by paying for placement. Anthropic and OpenAI bypassed a collective industry letter on open weights to pursue individual strategies. Anthropic CEO published a position paper calling for chip export controls and mandatory safety testing, while OpenAI Sam Altman is in Washington this week, meeting with the Senate Intelligence Committee. These moves suggest the legislative focus is shifting away from weight bands and toward more specific levers: the regulation of compute, distillation rules, and the cost of mandatory safety audits. A Delaware judge has allowed a defamation suit against Google to proceed to discovery. The plaintiff, Robbie Starbuck, provided evidence that he put Google's legal department on written notice about false claims before the chatbot continued to generate defamatory outputs to an alleged audience of 2.8 million users. Documented notice allows a plaintiff to bypass the standard hallucination framing at the pleading stage. By moving the case to discovery, the court will now determine whether these outputs were a result of design choices rather than random error. On Friday, the platform X removed 42,000 accounts for using chatbots to automate replies to human users. X has now defined LLM-driven engagement farming as a removable offense. This establishes a strict platform policy requiring a human in the loop for conversation, though the enforcement remains entirely at the company's discretion. OpenAI has launched Presence, an enterprise platform for voice agents. The company says the system already resolves 75% of its own support calls, handling tasks like identity verification and account actions without a human. The Presence architecture suggests a pivot in enterprise design. Following a year of failures for autonomous agents, this model relies on fencing, using scoped access, simulation, and pre-approved actions, rather than open-ended autonomy. This week confirms a clear pattern. A company's internal policy is often the only shield protecting private data and authentic conversation. But as regulators in Brussels and courts in Delaware have signaled, when those policies fail to prevent harm, the legal system will intervene to set the standard. Thanks to Clinician Assist for sponsoring.
We'll see you next week.